Hello, everyone. My name is Firas Rafi. I am an immigration attorney. I am licensed to practice immigration law in all 50 states. If you are a new here, consider subscribing to my channel. By subscribing, you will be notified whenever I post new videos, and it helps me out a lot. Just click the subscribe button below and turn on the notification bell so you never miss an update. Today's subject is Deferred Action for Childhood Arrival DACA program. On June 15, 2012, USCIS announced a prosecutorial discretion policy. It's called the Deferred Action for Childhood Arrival. It's called the DACA program. It has to do with certain young people who were brought to the United States as young children and do not present a risk to national security or public safety. They also must meet several key criteria that should be considered for relief from removal from the United States or from entering into removal proceeding, which is from the immigration court. Those who demonstrate that they meet the criteria will be eligible to receive deferred action for a period of 2 years, subject to renewal, and will be eligible to apply for work authorization. Now, the DACA is a discretionary benefit, and the criteria are simply factors for USCIS examiners to consider in deciding to grant the deferred action. Now, applicants are reminded to check the status of the Texas federal court litigation, which is, as of now, allow initial and renewal DACA applications to be submitted, but only renewal application to be adjudicated. What does that mean? It means that individuals who are already enrolled in the DACA and need to renew their protection can have their applications processed, while new applications will not have their initial applications reviewed or decided upon this time. Now, under the DACA program, individuals who meet the following criteria are eligible to apply. Now, the first requirement, the child was under the age of 31 as of June 15, 2012. The second requirement, the child came to the United States before reaching his or her 16th birthday. The third requirement, the child have continuously resided in the United States since June 15, 2007 up to the present time. The fourth requirement, the child was physically present in the United States on June 15, 2012, and at the time of making the request for consideration for deferred action with USCIS. Also, they have to have no lawful status on June 15, 2012. Now, there's another requirement that this child is currently in school or have graduated or obtained a certificate of completion from a high school or have obtained a general education development, which is called the GED, which is the homeschool program. It's called the GED certificate. Or are honorably discharged veterans of the Coast Guard or the Armed Forces of the United States. And the last requirement, have not been convicted of a felony or a significant misdemeanor. Significant misdemeanor means aggravated misdemeanor, or 3 or more other misdemeanors, and do not otherwise pose a threat to national security or public safety. Now, please note that the implementation, the DACA implementation memorandum directs ICE and the CPP. The CPP is the Customs and Borders Protection. The ICE is Immigration Custom Enforcement, and USCIS, which is the United States Citizenship and Immigration Services. All of these parties, they have to use prosecutorial discretion for people who meet the above criteria. Now, deferred action is a discretionary determination to defer removal of an individual as an act of prosecutorial discretion. For the purposes of future inadmissibility based on unlawful presence, a person whose case has been deferred is not considered to be unlawfully present during the period that the deferred action is in effect. That person is authorized to be present in the United States, but it does not confer lawful status on the person, nor does it excuse prior period of unlawful presence. Now, individuals who have been granted deferred action are eligible to receive employment authorization for a period of the deferred action, provided that they can demonstrate an economic necessity for the employment. The DACA recipients are also permitted to apply for permission to travel using an advance parole application, which is an application for a travel document. Now, let me just elaborate a little bit on the age requirements. There are a number of age requirements to qualify for DACA. Now, the applicants must have entered the United States before they turned 16 and before June 15, 2007. They must have been under the age of 31 as of June 15, 2012, and most DACA recipients must be at least 15 years of age or older at the time of filing of an application. Now, there's an exception to this rule. If the person is under the age of 15 and has been put in removal proceeding, or maybe there has been a final order of removal against them, or maybe they have took a voluntary departure order, these individuals or those individuals can apply for DACA even if they are under 15 at that time of the filing. Now let's talk about the travel requirements. DACA applicants must have resided in the United States since June 15, 2007 and been physically present in the United States on June 15, 2012. That means that some absence from the United States is permitted during that 5-year window, as long as the departure from the United States were brief, casual, and innocent. Brief, casual, and innocent is defined as follows. Now, the absence was short and it was for a purpose. The second requirement, that the absence was not because of an order of exclusion, deportation, or removal. The third requirement, the absence was not because of an order of voluntary departure or an administrative order. The purpose of the absence, while the applicant was outside the United States, was not contrary to the law. Now, the travel outside of the United States is permitted after DACA has been approved if the DACA recipient has applied for and received advance parole. Travel outside the United States without receiving an advance parole would automatically terminate a person's deferred action under the DACA. Now, advance parole for DACA recipients is more restrictive than for other categories, and is only available if travel is in furtherance of humanitarian purposes, which can include medical treatment or maybe attending funeral services for a family member, or maybe visiting an ailing relative. The second requirement is for educational purposes, such as attending school abroad, or maybe conducting academic research. Or the employment, it was for employment purposes, such as an overseas assignment, interviews, maybe attending conferences, training, or meeting with clients overseas. Now, if you have any questions about this subject, please reach out to me at 718-238-6300, 718-238-6300. Thank you very much.